Here's another big story about homeless. One week from today, the U.S. Supreme Court will hear arguments in a case out of Little Grants Pass, Oregon. It concerns what to do about homeless camping. It's a case that will have implications on homeless policy across the country. Let me refresh your memory. The case is called Johnson v. Grants Pass. It started when a group of homeless people sued the city over several ordinances punishing people for public camping. Anyone caught sleeping on sidewalk, streets, or city parks would face a fine of $295, and fines could go up to $1,200 and 30 days in jail if people kept sleeping on public property. Well, the Ninth Circuit Court of Appeals, that's the court that covers cases in the western U.S., they ruled in favor of the homeless people. They said the anti-camping ordinance violated another similar case that the Supreme Court decided back in 2018. That was called Martin v. Boise. And it laid the groundwork for recent homeless policy across the West. Now, in that case, the court ruled that you cannot punish people for sleeping outside, but only if they have nowhere else to go, as in shelter beds. So they ruled that it was a violation of the 8th Amendment of the U.S. Constitution prohibiting cruel and unusual punishment if you punish them for being involuntarily homeless. Martin v. Boise is the reason police cannot just go around arresting homeless people here in Portland and other cities if they aren't committing any other crimes. Grants Pass doesn't really have shelter space available apart from a transitional housing program run by a religious organization. And in order to go there, you have to follow their rules, which includes participating in their Christian religious practices. So the U.S. Supreme Court will be deciding if fining homeless people for public camping violates the 8th Amendment as cruel and unusual punishment. Now, this largely conservative court is set to start hearing arguments this coming Monday, so next Monday. The city's attorneys appealed the case up to the court, saying that the Martin case has vast unintended consequences on the homeless crisis for lots of cities. In their latest and final brief to the court ahead of Monday, they wrote, "The court can see the track record under Martin in the Ninth Circuit. Sprawling encampments, rising deaths, and widespread harms to the community as localities are forced to surrender their public spaces. For the past 5 years, Martin has tied the hands of public officials in responding to the homeless crisis and tasked federal judges with making difficult decisions on complex policy issues. The 8th Amendment supplies no workable standards to determine who is involuntarily homeless, what shelter is accessible, or when public camping prohibitions qualify as time, place, and manner restrictions." They go on to argue that people who are homeless are not forced to sleep on public property and that the 8th Amendment has nothing to do with public camping laws. And they say encampments threaten the rest of society with sanitation problems and fire danger. Now, there is another side, the plaintiffs, the homeless people. They argue that, well, their lawyers argue for them, that the city is trying to punish them for being homeless, basically for their status. In their brief, they wrote, "Although the ordinances purport to criminalize the conduct of camping, punishing homeless people for resting or sleeping outside anywhere at any time when they have no access to shelter and need a blanket to survive is not the punishment of conduct in any meaningful sense of the word. It is akin to punishing the conduct of breathing outside as a homeless person." We are going to be following this case as the Supreme Court talks about it next week, and you can bet a lot of local leaders will be as well. Of course, a ruling from the court will likely take months.